Hello, and today I'm talking about high hedges disputes. So this is disputes between neighbours about the height of an evergreen boundary hedge. So the law behind this is actually found in the Antisocial Behaviour Act 2003. So if one neighbour applies for and gets an order against their next door neighbour, then this is in effect an ASBO. The law is slightly different between England and Wales on this. So the Welsh Government has got quite a bit of guidance on this on their website. But if any sort of appeal needs to be made in response to an order being made by the local planning authority in Wales, then that goes to the Welsh Government, whereas in England it goes to the Secretary of State. Pretty similar other than that though. So when does a hedge actually fall under this complaint mechanism? So a hedge is deemed to be at least two trees in a continuous hedge line, whether that's either straight or curved, and at a height of in excess of 2 meters. So one neighbour may complain against the other neighbour because the hedge is too high, and they need to be saying in response to that hedge height is affecting their reasonable enjoyment of their property. The guidance suggests and encourages that there is discussion between neighbours, whether that starts as a chat with each other, and if a resolution cannot be reached, then that moves on to one neighbour writing to the other neighbour in a more formal basis. The BRE has issued some guidance on what's called the action hedge height, which is some data you put in about the location of the hedge, the dimensions of your garden, the location of your windows, for example, and it calculates what height over and above reasonable the offending hedge is. So it's worthwhile making that calculation by the online spreadsheet and attaching it to any written correspondence between the neighbours. Presuming that an agreement can't be reached between the neighbours from discussions or in correspondence between themselves, then the next step is for the complainant to bring their local authority in. How that happens is worth looking at the local planning authority's website for guidance on how to bring a complaint to the local authority. As I said previously, the complaint needs to be that the hedge is affecting the reasonable enjoyment of the land, and in considering that, the local authority will consider the privacy or shelter offered by the hedge, the lights blocked, the amenity value of the hedge, and also the legal obligations in respect of the boundary. The local authority, if they decide not to make any sort of enforcement order against the hedge owner, then there isn't an ability to appeal that. Any appeal, in a sense, needs to be by way of a complaint to the local government ombudsman or a judicial review, so that may become pretty expensive. But presuming the local authority do make an order against the hedge owner, then that is by way of a remedial notice, which orders the hedge owner to carry out works to reduce the hedge to a reasonable height. If they don't do that, then there's the risk of a monetary fine. And also, if they don't do that, then there is a risk that the local authority can actually enter onto their land, carry out the work themselves, and send a bill to the hedge owner. So that's the high hedges dispute system in a nutshell.